Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome to another episode of Empowering Plans. Today you have myself, Kelly Dempsey, and Kevin Brady back again to talk about some super interesting other rules that are happening. I know that Kevin and I talk a lot about COVID and other things that have been happening, but this one might be flying a little bit under the radar, and it's another one of these rules that have been bouncing around. So we wanted to, do this little podcast about it so we can talk about it. So if you hadn't heard, there's another proposed rule related to the independent contractor status. This was proposed on October 11th, 2022. So again, it's been a couple weeks, and the DOL has issued this new rule putting more distinctions between employees and independent contractors. And this proposed rule is a little bit more favorable to employees than employers. We'll go through, the background of how we ended up here, but the 2021 rule, which was affected, I guess, almost 2 years ago, really was kind of viewed as leaving workers vulnerable to misclassification. So it was more kind of like an employer favorable rule. And, the current administration is trying to kind of flip that script a little bit because they believe the 2021 rule was inconsistent with the federal court decisions that already exist. So at a very high level, the proposed rule will make it more difficult for companies to classify workers as independent contractors as opposed to employees. And this is really relevant. The long and short of it, before we get too far into this, is why does this matter? Well, it matters because independent contractors are not entitled to things like minimum wage and overtime pay. And, though it sounds intuitive, employee benefits because they're not employees. So the last piece, this employee benefits piece, is really the big one for self-funded employers and, their health plans. And this rule right now, obviously, the companies that are really feeling the heat and feeling the pressure are, companies like Uber and Lyft. They feel targeted, but the response to that has been that this rule applies to all industries, all types of workers. It has nothing to do with a specific industry. It's been across the board. And I would argue that very often when we talk about misclassification of workers, we see a lot of construction cases, which we'll get into that in a little bit. But according to some of the statistics that were thrown out there, this proposed rule and the proposed change has the potential to impact employers to the tune of $188 million. That sounds like a lot of money. So to quickly summarize what we're going to do, we're going to talk about kind of how we got here, what this new proposed rule actually says, when it may or may not go into effect, and then why it's really relevant. So I'll turn it over to Kevin to talk about kind of how we got here and what the rule really says.
Yeah, thanks, Kelly. I kind of jumped into it a little bit, and that's exactly right. So overall, federal law guarantees employers have certain rights: minimum wage, payroll, tax contributions, overtime pay, kind of all that stuff. And as you said, employee benefits specific to employees, not necessarily independent contractors. So, considering the fact that independent contractors don't have those same rights, this is obviously a really big deal. And just as a, FYI, many of the rights that are afforded to these employees derive from the Fair Labor Standards Act, so FLSA. And while that's kind of, what the rule is, documenting or amending in some way or adding context to, it's got a broader impact. It's going to impact, employee benefits and the like. I think that's really why, we're here talking about it today, is because it's going to have an impact on whether those individuals could be eligible for benefits. But overall, it's going to be something that's coming down from federal law. And it's something that, employees have rights that independent contractors don't. The categorization of employees versus independent contractors is not a new issue at all. This is actually something that's been litigated for decades. As Kelly mentioned, there's a rule back in 2021 issued by the DOL under the Trump administration. And really, as a result, there's been tons of different case law in various jurisdictions that have all kind of, come up with different tests or different ways to categorize these types of employees. But like I said, back in 2021, the DOL issued a rule that was a little bit more employer friendly. And that's basically just because of the test that was instituted to do those categorizations. And despite attempts by the current administration to kind of put a pause on that rule and to repeal it, still the guiding rule as of today, until there's a new rule coming out, this new proposed rule, until this new rule becomes effective, we still are dealing with that Trump rule from back in 2021. And the difference here is that the rule that was effectuated under the Trump administration was multi-factor, totality of the circumstance of analysis but it focused on a couple key factors that just tended to be more employer friendly. So I think that's really the main overarching idea here, is that, where we stand today is a more employer friendly, kind of considerations being taken into account, and we're considering whether someone's an employee or an independent contractor. So
Kevin, say that tongue twister like 10 times fast. Multi-factor analysis.
I know.
All these big words.
I know. Multi-factor, totality of the circumstances, analysis. We sound smart. I'm not really sure, but either way, like I said, current administration attempted to repeal this rule back when it was first coming out. But this one, the difference here now on the October 11th rule, rather than just simply repealing, what was already issued, this one's also offering a new way of doing it. So that's really why we're here, right? The current status under the proposed rule is going to really change the way that multi-factor test and that totality of the circumstances analysis is done. So hopping into what exactly the rule says, the DOL provides that there are 6 factors to consider when determining whether an individual is an employee or an independent contractor. So like I mentioned, the important shift here is that the rule focused on some core factors, and those tended to be employer friendly. But under the new rule, all 6 factors must be considered. This is where it really becomes more employee friendly, and it has a focus on the totality rather than those core factors. So just a high level, not to go super into the weeds on any of these in particular, but what's important here is that the 6 factors are the opportunity for profit or loss depending on managerial skill, investments by the worker and the employer, the degree of permanence of the work relationship, nature and degree of control, extent to which the work performed is an integral part of the employer's business, and the skill and initiative involved. So those are the 6 factors. The new rule basically says you have to look at all of those 6 factors and do a totality of the circumstances analysis and basically weigh them all equally. Beyond these, the DOL still permits that there's other considerations that could be considered as factors, but these are the core kind of ideas or things that we need to think about when we're categorizing those employers. And like I said, just the fact that we're now looking at these 6 different factors kind of all individually and how they all kind of coalesce into, how we're making that determination. That's a big shift from the previous rule, where we're really focused on a couple different things that were considered core factors. And the change here is going to be something that, potentially could have a major impact on how employers are classifying their employees. And I'll leave it to Kelly to kind of talk about why it's relevant and kind of the risks involved in that classification.
Yeah, I think I'm going to have nightmares about the listening in these words about classification of the factors and the totality of the circumstances. It's all just very confusing.
It's a lot. It's a mouthful.
Right. And before, like Kevin said, with these factors, if we go back to, we'll call the old rule, like before 2021, there was still a multi-factor test. And I actually think it was like 20 factors. So super fun, lots of things to consider. But again, why is this relevant? Why do we care about classifying employees and independent contractors? At the end of the day, again, it goes back to independent contractors have different rights than employees because they're not protected by the Fair Labor Standards Act. Another lovely little acronym that we have there. So that's really why it matters. And, employers have this tendency to expose themselves to liability when they misclassify those individuals. So it can impact like workers' compensation, and it can start adding up very, very quickly when we talk about unemployment and payroll taxes and, the wage and hour claims for like minimum wage and overtime pay and all those things. So it adds up very, very quickly. And we see a lot of entities wanting to actually offer benefits to independent contractors. Like that's been something that Kevin and I on the consulting team here at FIA have had a lot of questions over the last couple of years about individuals coming to us and saying, hey, I want to offer a benefit plan just to my independent contractors. And then we start, walking them through the analysis about the fact that if they do that, they're blurring the lines. They're blurring the line of independent contractor versus employee. And it actually, again, continues to extend down to ERISA, and the fact that ERISA defines a group health plan as an employee welfare benefit plan that provides medical care to employees and their dependents. So again, the words are very deliberate in the law, and that's why this is such a big deal, because it depends on whether or not they are offered a self-funded health plan or not. So again, the misclassification and miscategorization, it can lead to huge consequences for employers, not only related to the wages and overtime pay, but also under the employer mandate, which, yeah, it's still here, it's still around, there's still reporting requirements in the employer mandate. So if you misclassify your workers at the onset, maybe you aren't an applicable large employer. But if those people are actually employees, maybe you are an applicable large employer and you're supposed to be measuring and doing things differently. So, the numbers can start adding up math is not my favorite thing, but those employer mandate penalties start compounding very quickly. So employers can, get themselves into trouble really fast. And one of this example that I found from a blog that I read on a regular basis from an employment attorney, he's hilarious. I find him very funny, but he highlighted this case a couple months ago, and it started with a construction company. They had 10 workers that had bounced checks to construction workers. So they were independent contractors. And long story short, it turned into 800 workers being impacted and having denied wages because of being classified as independent contractors. So the math definitely gets messy, but it started out as these 10 bounce checks, and then the wage and hour division of the DOL started looking at this employer, this construction company, and realizing that there was actually 146 independent contractors involved in this situation that maybe were misclassified. And then they continued their analysis because this owner of this construction company also had 2 other construction businesses with his brother in a nearby town. And because of the shared responsibilities and the related activities, that defined them as joint employers, and therefore 653 more workers got added to the mix. So what started as 10 bounce checks that were maybe a couple $1,000s turned into about $230,000 being paid out to these workers. At the end of the day, very small amount for each individual. I think it breaks down to something like $300 a person. But still, how many employers have an extra $230,000 laying around that they could just pay out because they misclassified people? So this classification issue is a huge issue for employers. And again, I feel like it's one of those things that people don't think about unless it's right in front of their face. So Kevin and I are here to bring it to you and put it right in front of your face. So what's the current status? Right now, it is this rule that we're talking about is a proposed rule. So it's not currently in effect. And the comment period actually got extended to December 13th, which is 15 days past the original date that comments were due, because there's been so much pushback from some of these larger companies saying that, they need more time to adjust and figure out how this rule is going to impact them, whether or not it's that, $188 million that I mentioned earlier. So there is an extension. If the rule goes into effect as written, it will be published and become the law of the land. But as we've kind of already alluded to, one of the issues that comes up there is that DOL rules don't actually bind federal courts. And there's also many states have their own rules about independent contractor tests. So this is kind of a mess. It's probably going to continue to be a little bit of a mess as we navigate these waters and kind of figure out what the rule is going to be and how we have to determine whether or not people are employees or independent contractors. So again, it's likely to go into effect in early 2023 unless, somehow additional comment periods get extended or anything like that. So lots of caveats there, but I'll send it over to Kevin to kind of wrap us up here.
Yeah, absolutely. Yeah, I think it's relatively abnormal to kind of extend that comment period. So it's going to be interesting to see kind of whether that has an impact on anything. And, since this is a proposed rule and the new rules, eventually going to come out, it's possible that it looks a little bit different. I mean, who knows, how they're going to respond to those comments and if there's any changes that are going to be implemented there. But, we can only kind of comment on as we see it today and kind of what this proposed rule, seems to mean and seems to kind of, set the stage for us in 2023. So just to kind of conclude and go over a couple of things, just, overall, this is a change that's going to be relevant for a lot of different businesses out there. It's not necessarily just going to be the Ubers and Lyfts and the gig worker economies of the world, but really any employers that have a decent, amount or even only a few, independent contractors, because Kelly, went over the risks that go into misclassifying employees. And, at the end of the day, this is a proposed rule by the DOL, and like she just mentioned, this isn't necessarily something that's going to be the only consideration here. States are going to have, certain laws that impose their own tests. Federal courts may treat things differently. So at the end of the day, there's a lot of different things to think about. There's a lot of different kind of considerations, but you can always kind of use this as at least a guidepost in terms of how you're classifying your employees. Thinking about companies specifically that use independent contractors, they're going to be at risk now. Companies should really think about how they're considering their employees now, how they're categorizing them, and if needed, kind of go through these motions, think about these tests, kind of do it on your own, whatever it might be, and kind of come up with, are we in line with these kind of considerations here? And if not, maybe some individuals need to be considered employees, and thus, we're eligible for, the rights that employees are provided, such as, benefits, minimum wage, overtime pay, all those things that we already went on about. And then two, if you're an ALE, applicable large employer, then there's going to be employer mandate requirements and so on and so forth. So There's obviously a lot to think about. This is a complicated rule. Hopefully when it comes out in 2023, we'll get some guidance from the DOL on kind of how it's going to impact employers moving forward. But overall, hopefully this was kind of a helpful kind of summary overview on the rule itself and why it's important for employers to consider. So with that, I think we will wrap up this episode of Empowering Plans. So really appreciate it. Thank you.